Hi there. I'm Dr. Suzanne Bechtel, a passionate legal educator dedicated to making legal studies clear, practical, and even a little inspiring. On this channel, you'll find a growing collection of videos designed to help you prepare for the Certified Paralegal exam. It covers key topics, breaking down complex concepts, and offering study tips that actually stick. If you're looking for a deeper dive, check out my Teachable School, where I offer structured courses, interactive tools, and exclusive resources to support your journey towards certification. Watch this video to the end and you'll find a coupon code for a discount. Don't forget to subscribe and explore the playlists. Your success on the NALA CP exam starts here. Now, before we move on to the lecture, there are two important disclaimers. First of all, this is not considered legal advice. Everything shared here is designed to support your learning journey. Also, I am not a lawyer. This course is designed to help you understand the concepts of the exam. Hello. This lecture is covering limited liability companies and serves as an introduction to limited liability companies, and we'll focus on the unique characteristics of this form of business organization that's quickly growing in the United States. The goal of this lecture is to help you become familiar with these terms and topics concerning limited liability companies. We first of all have some vocabulary and what the characteristics of LLCs are, the laws of LLCs in the United States, the rights and responsibilities LLC members and managers have, and the advantages and disadvantages of doing business as an LLC. We'll look then to the organization and management of LLCs, how to form one, how they're operated, and how they are dissolved. Limited liability company lawsuit options will also be discussed, as well as the role of paralegal. Okay, introducing ourselves to the topic of LLCs. The limited liability company has many of the characteristics of a corporation. That includes limited liability for all owners or members, but it's usually taxed instead as a partnership. The LLC is an unincorporated legal entity distinct from its owners, and they're referred to as members. The owners are. The members of an LLC have no personal liability for the debts and obligations of the company. LLC management is very flexible. All the members of the LLC are granted the right to manage its business unless it's otherwise provided differently in the LLC Articles of Organization. And the statutes of most states provide that limited liability companies may exist indefinitely until the members dissolve it. And in that event, the LLC is an entity at will. Because the LLC is an entity separate from its members, the assets of the company are owned by the company itself, not by the members. So the members may transfer or assign their rights in the LLC, but they can't assign an interest in the company's assets. So they have no ownership interest for that purpose. Finally, individuals, corporations, partnerships, trusts, and other entities can be members of limited liability companies. In fact, LLCs have become more and more of a estate planning vehicle as well. We've seen this in one of the other previous ones, the family trust, the family partnership. Okay, moving on. So the characteristics of the LLC, we'll look to some tax characteristics of it. So the IRS has checked the box regulation, and they brought these on in 1997. And with this check the box regulation framework, when the members of an LLC file an income tax return for the company, it's taxed as a partnership unless the members check the box on a form to elect to be taxed as a corporation. The LLC member will see this a lot when doing tax forms and whatever, choosing the partnership versus corporation form of taxation. Single member LLCs are disregarded as entities separate from their owners for income tax purposes. So if the sole member elects to be taxed as a corporation. All right, I have an LLC and I elect the the partnership version. A few states impose corporate income taxes on LLCs. Members of most LLCs report their income in the same manner as partners of a general partnership, and then the company's income is reported to the IRS on Form 1065 partnership return. Professional limited liability companies are also an option in the United States. The statutes of most states will permit the formation of professional LLCs. These are for doctors, lawyers, and other professionals. Membership in a professional LLC may be restricted to those who are licensed. In other words, the LLC can be designed with a restriction of licensing requirements. Members of a professional LLC are personally liable for their own acts of negligence or malpractice. Looking at this historically, interestingly enough, the first state to have legislation for LLCs was Wyoming, and I was there. I lived there for many years. And then I moved to Florida. So I went from Wyoming to Florida. So we started with these in Wyoming. They're actually historically a German form of doing GHBZ, I think is what they're called in Germany. And so I believe that is the historical beginning point of this concept of a limited liability company. Anyway, other states in the 90s started to pick up on this excellent tool for business, for estate planning, for many, many good reasons. And so there are more LLCs than there are basically other forms of business organizations, including corporations. Used to be, you just set up a corporation years ago. I remember that. Anyway. The Uniform Limited Liability Company Act was adopted by the National Conference of Commissioners on Uniform State Law in 1994. And this uniform law was drafted to include many of the provisions that had already been adopted by state laws. So they took these provisions and brought them into a focused uniform form of laws. States don't have to adopt them. They don't have to be adopted in their entirety. You know that about uniform laws that are that the national conference has put together. These will go. These will be drawn from by states when they're writing their own legislation, but they don't basically copy paste the whole thing. In 2006, the Uniform Law Commission drafted a new version of the Uniform Act, and it referred to it as the Revised Uniform Limited Liability Company Act. And a few states have adopted either version of this particular Uniform Act. The state and federal securities laws do not apply in most cases to LLCs. They have a small number of members. Those that have a small number of members who all participate to some extent in the management of the LLC typically bypass securities. But those LLCs that may be subject to state and federal securities laws are those where the members' interests are determined to be an investment in a common enterprise and with an expectation of profits to be derived solely from the efforts of the others. So 3 factors that go into that. And those will be in your lecture notes also on this slide. So the advantages. The advantages are many. The LLC, compared to other forms of business, you know, there are fewer restrictions on ownership. There's increased ability to raise capital for the business. The tax treatment and the flexibility of management are those. Uh, there are disadvantages. Those include doing business as a limited liability company, um, the possibility of piercing a limited liability company veil, lack of uniformity in limited liability law among the states, informalities and reporting required of limited liability companies. So looking at the owners the powers of limited liability companies. The limited liability company is a separate entity, and it's granted certain powers by state statutes and its articles of organization. So LLCs have the same powers as individuals do in all things that are necessary or convenient to carry on business. So you think it's like a corporation. It's an entity, and the people, the members, and individuals are the ones that put the corporation's work into action. Members' rights in an LLC, they're granted the right to manage the business unless the LLC company articles of organization say otherwise. Members of LLCs are granted certain rights also by the articles of organization, and in the lecture notes for slide 12 you'll see a long list of rights that are typically granted to its members in the articles of organization. Equal right of management might be in there, reimbursed for liabilities. So it is a fairly long list of a dozen things. So you can look at the lecture notes and get a handle on that. So all members of a member-managed LLC are considered agents of the company. And the LLC company, if its LLC company is manager-managed, the organizers or members elect a board of managers to manage the business of the company. And so they typically are named in the articles of organization. And in a manager-managed limited liability company, the managers act as agents of the company. So the other members do not. Members would not be considered management, but managers would. Okay, so take that literally, manager. The managers serve in capacity similar to that of a board of directors of a corporation, and they owe a fiduciary duty to the other members. So forming an LLC is really simple. The limited liability company is formed by filing articles of organization with the Secretary of State or other appropriate state authority. What we include in that is, it's really a simple form. It's a one-pager. Name of the company, the address of the initial designated office. Read the list. It's right here. I won't waste any airtime on it. It's a very simple type of business to start up. You need to make sure the name is available. So if you're the paralegal working, you would check with the Secretary of State or other organization or other authority, state authority, to find out if the name is available. They feel like it's in the best interest of the company. Certain members can be personally liable for certain debts and obligations. But otherwise, members generally don't have any personal liability for any debts and obligations of the company. So on the organization and management of an LLC, they may be member managed or manager managed. And we have already seen one difference above as far as agency factors as to does member managed or manager managed make a difference. If it's member managed, there's an equal right in the management of the company, and has the right, and each member has the right to act on behalf of the limited liability company. Back to agency. A repeat of that overlap coming along here, but it will help you remember. Some matters that have extraordinary needs, they might need the consent of all members. This is something that would be included in the LLC Articles of Organization. But to amend the operating agreement to approve some acts or transactions that members or managers would otherwise violate the duty of loyalty, amendments to the Articles of Organization, and the compromise. There are several listed, and this would be on slide 15, the lecture notes of slide 15. So again, I won't waste any airtime on that. There's quite a bit. The operating agreement is the document that sets forth the agreement of the members. It's sort of like, the partnership agreement and other forms of business. It's similar to the bylaws that are adopted by a corporation as well. Statutes don't normally dictate what must be contained in the operating agreement. The state statutes prohibit only provisions that unfairly restrict the rights of members or limit the duty of loyalty owed to the members by managers. Limited liability companies in most states are subject to annual reporting requirements with the Secretary of State or other state authority, usually on forms provided by that authority. It's a simple one-page form where I live. It's a piece of cake. Let's see. Just anything here. Oh, okay, next slide. The limited liability company's initial assets are going to be the contributions made by the company's members. If it could be started without any assets. That's how I began mine. The articles of organization or the company's operating agreement may have some provisions as to whether members must make additional contributions and under what types of circumstances they're required. The LLC can sell additional member interests, and that's another to help raise funds. Having this variety of types of membership, we've already mentioned a trust or human business, all these types of that can provide a lot of capital opportunities. So the LLC is very fondly thought of as that type of flexibility for getting capital. Profits are allocated to the members of the company, and that goes in proportion to their initial contribution or some other formula that the articles of organization might include, or the operating agreement. One of those two things can affect that. Distributions are made to members according to the operating agreement, or if a statute provides otherwise. So next slide. Lawsuits. We talked about derivative lawsuits in the previous lecture video when we were talking about corporations. So look back there to some information about derivative lawsuits. It wouldn't surprise me if there's a question on the exam that somewhere tucked around, either in civil litigation section or this one for business might just show up. So look that up and just know it has to be a purpose for it. And at the end of the day, money comes back to the business, not to shareholders or other people in interest. It's a purpose for seeing problems that are happening within a business as far as mismanagement and that sort of thing. But anyway, as a separate entity, limited liability companies may sue or be sued in the company's name. The derivative lawsuit idea comes about on behalf of the limited liability company. One or more members could recover damages sustained by the LLC, and they can bring suit against the company to protect their rights and interests under the operating agreement or under law. So that is an action by members. Okay, to dissolve an LLC, one or more of the members may be dissociated from the LLC without causing its dissolution. So by choice or by, non-choice, the members can leave and not cause dissolution of the LLC as a matter of law. A member may dissociate from an LLC by withdrawing. They do this in writing, or by transferring all of their interest in the company. And it could also be caused by death or bankruptcy, appointment of a guardian for the member, unanimous vote of other members under certain circumstances. So someone gets ousted by a unanimous vote. State statutes and limited liability companies' articles of organization are typically where we provide terms and conditions for the purchase of the dissociating member's interest, if there is any, and the remaining partners wish to deal with that. A dissolution of an LLC can occur when it's stated in the company's article of organization, or when it's agreed by the members, or when a dissociation takes place. So we're getting a little redundant, but nonetheless, trying to hit as many points individually as I can to look at this from different angles for purposes of being tested on the exam. State statutes can provide a limited LLC. They can dissolve when it becomes unlawful to continue in business. We've seen that before in other conversations about other types of business. You can't run a business of the legal nature. Once it's been made, once a decision gets made to dissolve, the winding up process begins, and that's when the assets get distributed. They will be distributed according to the operating agreement and state statutes where so applicable. And in general, the assets of limited liability are first paid to creditors of the company. So there would be a priority effect to the distribution of the assets. First to creditors, which makes sense to me anyway. Then you file the articles of termination with the Secretary of State when the business is finished and wound down. Under certain circumstances, like when members use the company to defraud creditors, the limited liability company piercing the veil can come about, and the members may be held personally liable. A limited liability company is considered a foreign company in every state. Other than its state of organization, you can file an application for a certificate of authority to transact business in a foreign limited LLC with the Secretary of State or whatever agency of the foreign state is where the foreign state is located. This gets a lot like the typical paralegal role in business, watching over things, keeping up with the research out there about LLCs, drafting the documentation like the articles of organization and the agreement, helping with transfer of property if that needs to be done. It typically does. So don't forget the lecture notes and review questions for this topic are available to you. And have a great day. I hope you got some good information from this video lecture. Don't forget that I have a Teachable school account. Here is the address for that, mayananda-s-school.teachable.com. The name of my school is Mayananda. And also, there's a coupon here for you to save some money. And finally, good luck on the exam. And don't forget to like, share, and subscribe.